Welcome back to the Grife Law Podcast. I'm Abby, and today I'm here with Mike Grife from the Grife Law Firm. Good to have you back, Mike. Thanks for being here today.
Good to be here, Abby. Great to be with you.
So, Florida has one of the most unique car accident systems in the country. It is a no-fault state. The minimum coverage numbers are low. There is a hard 14-day medical window that kicks in the moment the crash happens. And in 2023, the legislature rewrote the core rules with HB 837. Today, we are going to walk through exactly how to file a claim in Florida and the most common mistakes that quietly destroy claims every single day. If you have been in a crash in Boca Raton or anywhere else in Florida, this episode is for you. So, getting into the first question, most people panic after a crash and have no idea what to do first. So what should someone do at the scene of a Florida car accident to protect both their health and their claim?
Well, there's a few things that Floridians should do if they're involved in a car crash in Boca Raton, Palm Beach County, or anywhere really throughout the state. The first thing that you want to do, if possible, is document the scene, right? Because time can destroy evidence, people can destroy evidence. So if you're involved in a car crash, then you want to take photographs if you can. I mean, some people are so injured, they're basically get cut out of the car by the paramedics, put in an ambulance, and go to the hospital. So if that's the case, then that's a whole different equation, right? Then it's just about your health and making sure that you get the treatment you need. But other than that, if you're able to, you should document the scene. Take photographs of your car, take photographs of the other car, including the driver's license and the license plate of the vehicle. If in the event that they're going to drive away or something like that, this way you have all that evidence preserved. We could see the crush damage of the at-fault vehicle and of your vehicle at the scene. So that's really good if you could document, the scene, the evidence. If there's debris, say part of your car got thrown into the road, you want to take pictures of that and where it landed, things of that nature. Another thing you want to do is you want to get medical treatment very, very quickly, right? A lot of us are, kind of like raised to be tough guys and tough girls. And, hey, listen, if I break my left arm, I'll just use my right arm, no problem. But when it comes to car accidents in Florida, as you said, the laws are really kind of funky. And one of the laws that, I'd like to talk to you about today is the PIP law, the no fault law, which drives a lot of my clients crazy, but it is the law that we got until it gets repealed. So, but basically the PIP law mandates that you have to treat within 14 days. But you don't want to waste time because these insurance companies, if you don't treat very quickly, even if you're just trying to be tough and say, hey, I'll sleep it off, they're going to say, oh, well, if you're really hurt, you would have, treated, quicker than you did. So don't hesitate if you're injured, if you're feeling pain, to go to the emergency department, to, go to an urgent care center, to go to a doctor very, very quickly. And again, definitely within 14 days, because you don't want to give up that $10,000 worth of PIP benefits that you're going to get, which you do lose if you don't treat within 14 days of the crash. So don't hesitate to go to the hospital, go to the urgent care, get medical treatment, and tell the doctors there all the pain you're in. Start from your head, go down to your toes, and everything in between. Tell them what's hurting. Very, very important. Another thing that you want to do after a car crash is you want to call a lawyer immediately before you call even your own insurance company, because I can assure you that your insurance company doesn't have your back. They're looking to have their own back, right? Like they want to save as much money as possible. And if you did anything that they could blame you for, or if you give a statement while you're still kind of excited and you haven't really thought about it and all the angles of the crash and things of this nature, then you could wind up saying something that could even shoot yourself in the foot. The only people who really have your back are lawyers like me who represent the injured. And I've been doing this for 20 years now, and I've represented thousands and thousands of people who have been in car crashes, and I have the experience, the knowledge, and the wherewithal to put the law on your side. So definitely call me, Mike Grife at the Grife Law Firm, or another highly skilled lawyer. Don't call like a mill lawyer who doesn't go to court and doesn't litigate, because that could almost be worse than calling the insurance companies. But don't speak to the insurance company for the other driver, even if they could be a wolf in sheep's clothing. oh, we just want to make sure you're okay. Oh, we just want to, see if there's anything we can do for you. No. I've seen these adjusters try to get people to sign releases for nominal amounts, $2,000, $3,000, $4,000. And basically before they could even get treatment and realize how bad they're hurt, and they're already giving up their rights. So speak to someone who really has your back and your best interests at heart, because that's what you should do after a crash to protect yourself, protect your family. And of course, if you're catastrophically hurt, we're going to get that PIP 10,000. We're going to make sure that all the at-fault parties are going to be held responsible. Even, like sometimes you think outside of the box, right? And you think about, it's not just the other driver. Is there construction issues? Is there safety issues of, say, a parking lot or a highway or a guardrail and things of that nature? So there's so much that goes into really analyzing a car crash that you want to get a lawyer on your side as quickly as possible.
And most people don't realize there's a separate state reporting obligation beyond the police report. So when is a Florida driver legally required to report a crash, and what is HSMV Form 90010?
So I've had a case very recently where somebody was crossing a street, minding their own business, and they got hit by a car. It happened to be somebody who was driving for a ride-sharing company, right? So basically, my client got knocked down. He said, oh, is it okay if I just, you could take a picture of my driver's license, you could take a picture of my car, but I got to go. And my client felt bad for them. So they're like, okay, fine. She had all the evidence, but she had to go fill out that form that you just mentioned and file and get a crash report so that she could, hold this person responsible, this Uber driver responsible for the damages that he caused, because she was very injured. So you definitely want to look, ideally, even if the other driver's nice, even if the other driver makes some kind of impassioned plea, 99.9 times out of 100, you want to tell them, no, I'm calling law enforcement. This needs to be documented. You call 911, you let the police come, and, they fill out a report, and that's going to help you with your case. You're going to have a law enforcement officer who's documented everything, documented the scene, how the crash happened, the property damage, things of that nature. But if in the event that somebody flees, or, you've already agreed to, just take their insurance information, driver's license, things like that, and you allowed, you both left the scene, then yes, you need to fill out the forms and you need to get a crash report, because that could be very, very critical evidence. Not that it's admissible at trial, but it kind of like gives all the information that's needed to help hold the at-fault party responsible.
And this is the one rule that catches more Floridians off guard than anything else in the system. Why is Florida's 14-day PIP rule the single most important deadline after a crash?
So Florida's 14-day PIP rule is so important because it's $10,000. You got $10,000 on the line, right? And the defense is going to get a set-off for that, whether you treat or not. Okay. So you need to go and treat within those 14 days, because that's going to trigger your PIP benefits for medical bills, lost wages. In the event of wrongful death, there's actually a funeral benefit that comes with that, which obviously you don't have to treat for, but I think it's important that the people know that. So with regards to the 14-day deadline, again, it's $10,000 that you have on the line that you're going to get towards your medical bills, which is, again, another reason why you should treat, because, you're going to have a claim opened up anyway with your insurance. You're going to get $10,000 towards your medical bills, and you're not going to have to pay out of pocket. But if you don't treat within 14 days, then those benefits are lost. They're gone forever. So that's why it's so important that you get some kind of medical treatment. And again, when you go, even if you go to your primary care doctor, you have to let him or her know, hey, listen, I've been in a car crash, or I got hit by a car. Because what's really interesting, Abby, is even if you get hit by a car, you're a pedestrian on foot, the PIP law still applies, and you still have to treat within 14 days. So that, people get a little confused on that too, but I hope, everybody watching out there and listening knows that now. So, whether you got hit by a car, you were in a car crash, you're on a bicycle, whatever it is, a scooter, treat within 14 days, because you want to get $10,000 towards your medical bills or lost wages or what have you. And if you don't treat, that $10,000 could be set off against you anyway.
Yeah, that's really important for people to know. A lot of people walk away feeling fine and skip the doctor entirely. So, where should someone go for medical care after a Florida crash, even if they feel fine?
Great question. So obviously the first thing that you should consider is whether or not you want to take the ambulance or have a family member drive you to the hospital, because that's the best way to find out whether you have a serious injury. They should do diagnostic studies, CTs, possibly MRIs, to find out really if you have any damage to your spine, to your legs, to your shoulders, what have you. Because the last thing you want is to have, or, of course, if you have a brain injury, because the last thing you want is to try to walk it off and to try to be, hey, I'm going to sleep on it. But if you have, a very serious injury like a brain bleed or a fracture in your spine, and you don't get that diagnosed and stabilized early on, then that can get really, really devastating. The fallout could be catastrophic. So better safe than sorry, right? I'm sure, you've heard your mom say that 1,000 times, right? Better safe than sorry. So, your first option is always take the ambulance or have a trusted family member or friend drive you to the ER, get checked out. If that doesn't happen and you're going to try to sleep it off, if you wake up the next day and you're still in pain, you could, of course, still go to the ER, right, to your local hospital or to an urgent care. A lot of urgent care centers take PIP insurance and understand PIP insurance. So again, call your lawyer first so we could set up your PIP claim. And while you're under all the ill effects of the crash and your injuries and things like that, you're not giving statements to your insurance company before you have a lawyer who's going to basically make sure that you do so in a way that's favorable for you. But you can go to an urgent care and just call them first and say, hey, do you have PIP? Do you take PIP insurance? And then you'll have a claim number, hopefully, and they'll take your PIP and life is good. You get treated. They have x-ray machines and things like that. And these urgent care centers are always taught the doctors and the PAs and the nurses who work there, hey, listen, if this patient's condition is, beyond what we can handle, or we don't know if we can stabilize this patient, they will tell you, hey, you need to go to the ER. You need a brain CT. You need a spine CT. Your condition is too advanced for what we do here. So going to the urgent care within 24 or 48 hours is always a good idea as well. I think kind of like maybe the last resort to me would be going to your primary care doctor, because a lot of primary care doctors are treating more chronic conditions like high blood pressure or things of that nature, or they're treating, like, hey, you have the cold or flu or something like that. So going to them with orthopedic injuries to me isn't the best, but of course, it's definitely better than nothing because you want to treat within 14 days. So I would say the emergency room is always your best bet. They're always equipped at these hospitals. Here in Boca Raton, we have Delray Medical Center right close by in Delray Beach, which is a level 1 trauma center. So they have, basically everything needed to diagnose injuries, and they should diagnose it. If they misdiagnose it, definitely call me there. But they have everything you need to do all the diagnostic scans and make sure you're not injured. So the ER first, urgent care second, primary care would be a distant, fourth or fifth. And I would say in between there, third would be if you can get in with an orthopedic doctor, something like that, who's trained to treat orthopedic injuries, broken bones, spinal injuries, extremity injuries like knee tears, shoulder tears, things of that nature. Those are the doctors that you want to treat within the facilities you want to go to.
Beyond the basics, there is a lot of evidence that can tip the scale. So, what evidence beyond photos and medical records can make or break a Florida car accident claim?
That's such a great question, Abby. I'm really happy that you asked. So really, I think the big piece of evidence and kind of the big technological advancement in, car crash cases from when I first became a lawyer till now is the proliferation of the event data recorder, right? So the event data recorder is often called the black box. That's what people like to call the event data recorder. So it used to be, before event data recorders, you would have accident reconstructionists and they would measure crush damage, right? They would literally measure how big is the dent or how big is the damage to this car and that car and where is it? And they would actually have to reconstruct it based on the angles and things like that and how bad the crush damage was. And they would try to determine, the speed and the delta V, which is the change in velocity after the impact and things of that nature. And it was a lot more, Abby, open to interpretation than it is now, because now you have event data recorder. Event data recorder doesn't lie, right? If they say that the gas was pressed at 100%, and no one hit the brakes before the crash, or the gas was pressed at 60%, and they hit the brakes like 1 second before the crash, and then it's going to have, like, normally the event data recorders count back 5 seconds before impact. So you'll know from 5 seconds before impact through the time of impact, you'll know a lot of things. You'll know how fast the vehicle was traveling, whether the gas pedal or the brake was pressed and when it was pressed, and how much it was pressed. Like I said, you could have the gas pedal 100%, 90%, 80%, then they hit the brakes and things like that. So the event data recorder is a huge piece of evidence. But here's the thing. If you don't hire a lawyer quickly, and especially a good lawyer, like the Grife law firm, like we have the best lawyers here, right? If you don't hire a really good lawyer soon, they're not going to know to look for the event data recorder. They're going to let that slide, okay? And then once the car gets totaled out and it winds up in, the Middle East, or it winds up in a junkyard or wherever they're going to send it, then bye-bye event data recorder, and you're not going to have access to that critical evidence. So that's really a piece of evidence that a lot of people aren't aware of, but a really good lawyer will tell you, hey, look, we tell all of the defendants in our car crash cases, preserve the evidence, preserve the vehicle until we can download the black box if need be. So that's, I think, a really big advancement in technology and a piece of evidence that not many people are aware about. But of course, the other end of that, because that's the liability side, but the other end of that is the damages evidence. And the evidence that I need for damages is medical treatment. Because anyone after a car crash can get in there and say, oh, I was really hurt. But if you don't treat, if you don't go to the doctor, if you don't go to the emergency department or an urgent care center or an orthopedic doctor, how are people going to believe you? How am I going to have the evidence to go prove your damages and prove your case? So you have a lot of liability side stuff, right? Like the event data recorder, photographs of the vehicles, because that's another thing, is that, we'll make sure that the vehicles are preserved until we could take photographs of them. In the event you're not able to, or in the event you didn't, which is fine. And even some people just will snap 1 or 2 photographs, which is understandable because they have bigger concerns after a crash. But we'll take 300 photographs and we'll get every angle and we'll leave no stone unturned. So you want all that physical evidence, you want the event data recorder, and of course you want the damages evidence, which is medical treatment.
That is great insight. Thank you so much. Okay, we have covered what to do at the scene, the 14-day medical window, and the evidence that makes or breaks a case. So now let's get into how Florida's no-fault system actually works and what the HB 837 changed in 2023. So Florida's system is not like most other states, and most people have no idea. How does Florida's no-fault insurance system and PIP coverage actually work?
Well, Abby, I can tell you that Florida's no-fault system is one of the most perplexing things that we have in our state. And I love Florida, but the PIP system is really not the best, and it kind of drives my clients crazy, because here's the thing. Here's what's weird about it. You ready? So you could be crossing the street, have the right of way, and a drunk driver could hit you because the drunk driver blew a red light, okay? And because of our PIP no-fault system, the first $10,000 of your medical bills is going to come from your own insurance. And people say, wait, I did nothing wrong. I was just crossing the street. Or, I was stopped at a stop sign and I got rear-ended. Why is my insurance have to get involved? And I have to explain, hey, we have these weird laws in Florida, these PIP laws, no-fault insurance, that say regardless of who's at fault, you only have, the first $10,000 has to come from your insurance. So that's kind of like what's unique about it. Another thing about it, and I think this kind of ties to our earlier discussions, Abby, is in the PIP laws, they have a law that basically says for a plaintiff in a personal injury auto accident case to get non-economic damages, human damages, mental anguish, pain and suffering, loss of capacity for enjoyment of life, for you to get those sort of damages, you have to prove a permanent injury. So that's another reason why you want to treat within 14 days, because if the jury doesn't find that you have a permanent injury, you can't collect human damages. So that's why building the evidence right up front as part of the PIP statute, but it also applies in your personal injury case. That's why treating early is so important, and making sure that we can prove that you have a permanent injury from the crash to get you the money that you deserve. So because it's this no-fault system, again, because you could have 0% fault. You could be the most innocent person minding your own business and get rear-ended, or someone runs a red light and hits you, whatever. The first $10,000 is always going to come out of your insurance for medical bills and so forth. So it's a little crazy like that. And then you have the permanency issues. So, the other thing about Florida law that I think is very, very important that everyone should know, everyone who lives in Florida needs to know this. Florida is one of only a handful of states in the country that doesn't require drivers to have bodily injury insurance. So there's a lot of people walking out there that have no insurance at all. A lot of states have $25,000 minimum, $50,000 minimum. Florida's got zero requirements. So your insurance company sells what's called uninsured and underinsured motorist coverage. This is critical for everyone who lives in Florida, because if someone's involved in a serious crash and the other driver is destitute, doesn't have bodily injury insurance, doesn't have assets that you can collect, right? Even if they have a home, it could be homesteaded, and that'll be uncollectible. So because Florida's got these really weird laws that don't require bodily injury insurance, you really need uninsured, underinsured motorist coverage. So please make sure you have that.
Mm-hmm. Yeah, that is great advice. So PIP is capped. So when does the claimant actually get to go after the at-fault driver directly? When can a Florida crash victim step outside the no-fault system and sue the at-fault driver?
So you could sue the at-fault driver straight away. You could sue them that day. You could sue them the next day. You have a 2-year statute of limitations, which was part of that House Bill 837 that you mentioned earlier, shortened the statute of limitations from 4 years to 2 years here in Florida. That was passed in 2023. But so the PIP benefits that you get are completely separate from your third-party case against the at-fault driver and the at-fault vehicle owner. And if they're working for a company, the corporation they're working for, it's just kind of like different paths that you travel down, if you will. If you can imagine like two parallel roads, one road is the PIP, the other road is the bodily injury or the third-party claim. So you don't have to exhaust your PIP benefits or even make a PIP claim to go against the third party, bodily injury, the person who caused you a crash. You could literally sue them that day if you want. However, a smart strategic lawyer is going to say, hey, look, you need to treat, you need to probably exhaust your PIP. You need to, get the evidence you need, whether it's MRI, CT scans, what have you, so that we can prove permanent injuries. Then let's present a legal demand package to the insurance company for the third party, the at-fault driver who caused the crash, because look, we don't want to keep you tied up in court for 12, 18, 24 months if we don't have to. If we can get you paid, save you that cost, save you that time, and get you on with your life with a big smile on your face, hopefully, then hey, great, that's what we like to do. But, sometimes you do have to file a lawsuit, and sometimes, to get, the really most justice, because we're here for full justice. We don't want a half a cup of justice. We want a full cup of justice, right? So to get that, sometimes you do have to file a lawsuit and go to court and do a jury trial and let 6 people in Palm Beach or Broward County or wherever, decide what your case is worth, because the other side's insurance company is being cheap and stingy. But to answer your original question, yeah, you can it's completely separate. So you don't have to worry about your PIP benefits to bring a third-party case against the at-fault party. You could do it straight away.
So this is one of the biggest changes to Florida's personal injury landscape in decades. How did HB 837 rewrite the rules for Florida car accident claims in 2023? I know you mentioned it a little bit before, but if you could expand on it, maybe?
Happy to do it, Abby. So HB 837, unfortunately, was one of the most anti-consumer laws to ever be passed in Florida. It did change the landscape. It made it more difficult, but we're still winning. We're still doing our thing. We're still representing people with tremendous aggression, skill, dedication, and getting top-level results. So we don't worry about that. We don't worry about the haters. But, for HB 837, basically it did a few things. So the first thing it did, again, and we talked about a little bit earlier, was it shortened the statute of limitations from 4 years to 2 years. Now, in fairness, it wasn't applied retroactively. So if somebody was in a car accident 3 years ago when this was passed, you still had your claim up to 4 years. But from that date forward, in March of 2023, when it was enacted, through the present, the new statute of limitations is shortened from 4 years to 2 years, which means for everyone out there that if you're involved in a car crash and you don't file your lawsuit within 2 years of that crash, you could lose the right to sue forever. You will have no claim, which is another reason to get a lawyer involved on your side very quickly to protect and maximize your rights. So that's one thing it did, was it shortened, the statute of limitations. Another anti-consumer part of HB 837 was that it enacted this comparative fault, right? The modified comparative fault, where it used to be in Florida that even if the defendant was 1% at fault, you can collect that 1%. You would win and you would get your prevailing party costs and things of that nature. Now, under HB 837, if the plaintiff is 51% at fault or more, their recovery is reduced to zero. So that's a big deal. It used to be, hey, look, even if the plaintiff is 60% at fault, 70% at fault, and the defendant is 30 or 40% at fault, and my damages were, $500,000, and the at-fault party was 30% at fault, I could still collect $150,000, and so on and so forth, right? Whatever your damages were would be reduced by your percentage of fault, and you can collect. To make the math a little bit easier, if your damages were $100,000 and the plaintiff was, say, 60% at fault, the defendant was 40% at fault, you would get $40,000, right? Now, if you're 51% at fault, it doesn't matter if your damages are millions and millions of dollars. If you're more at fault than the defendant, per the jury, you get zero. So that's something to collect. However, that doesn't mean that even if you have some fault in the crash, that we can't get a huge sum of money for your damages, right? I mean, because that's why you hire us, is to put the law on your side, to get the black box, to get all the photographs, to get all the evidence. And if we can prove that the defendant is, 50% or more at fault, then you win, and you still get to collect the damages that the defendant is responsible for. So don't get discouraged if there's kind of a liability dispute, but you're in the right, then still pursue your claim, right? Still call the Grife law firm and pursue your claim. So that was another thing that it did. And a third thing that HB 837 did was made bad faith cases considerably more difficult. It kind of put an onus on the plaintiff to really kind of like do the defendant and insurance company's job for them, which was very kind of odd. It's just such an anti-consumer bill. The other thing it did was it said that, on bodily injury claims, that the adjuster has 60 days from the date that it receives evidence that the case is worth the same or more than the policy limits. So it kind of set this 60-day standard in motion. But really, for the people out there, that's something for you to worry about. That's why you hire me, so I can worry about these things and win for you no matter what the law is on these issues, because there's always strategies and ways to represent the injured, to represent the people, to do a great job. So HB 837 was very anti-consumer, but like I said, we're not discouraged. We're still representing people with tremendous aggression, skill, confidence, and competence, and just, doing our thing and getting great results.
So let's say someone has been in a crash and they have seen a doctor, they have the police report. What is the actual sequence? How does the Florida car accident claim process actually work from PIP notification through a third-party bodily injury demand?
Yeah, that's a great question. So there's a lot of things that we do as your lawyers behind the scenes to get your claim going. So let's just say you're in a crash, you have your crash report, you've gone to the ER, now we're meeting up, right? Whether we meet over Zoom or you come to our beautiful office in Boca Raton, or, we just speak over the phone and we sign up through DocuSign. But once you retain us, we make sure that we get, the first thing we want to do is get, number one, obviously make sure that you're good, right? We want to make sure you've gotten the medical treatment you need. You feel stabilized in terms of, your medical treatment. So that's like really number one, is how can we help you, right? A lot of people after a car crash, one of their biggest concerns is that their car might be totaled, right? So now they have no transportation. So is there rental insurance? Is the at-fault party going to take responsibility and put you in a rental? Do you have rental in your own car? Is there a diminution of value claim because now your car isn't worth what it was before the crash? But really getting you situated physically so that you're in the best possible position to recover from your injuries, to have your injuries diagnosed, documented, and set you on a path to recovery as soon as possible. Number one. Number two, let's see what we need to do to get your car fixed or to get it totaled out and get you compensated for that car, get you a rental, make sure that you have wheels or transportation. And if not, then we're happy to put you in an Uber and until you can get up and running, right? So we're happy to, kind of like bridge the gap for you between, where you were before the crash until you can get into your next vehicle. But on the legal side, right? So really what we want to do is get the policy limits as quickly as possible. What is the bodily injury coverage for the defense? Do you have any uninsured, underinsured motorist coverage? So that we know, like, basically kind of, where the borders are almost, or like, what we're kind of dealing with. And of course, we're going to look and see, is the defendant, recoverable, right? Like, do they have a ton of assets? If they're underinsured, hey, look, maybe we'll just go after their assets, like whatever it is. But, so we want to get the bodily injury and policy limits as quickly as possible. We want to put your health insurance on notice because under Florida Statute 768.68, they're responsible. They have a right of subrogation for the medical bills that they pay. So we got to put your health insurance on notice. And then basically make sure that, you go to great, highly skilled doctors who are going to provide you with amazing care, who are going to treat you right. Make sure that, the PIP is paying the hospital bills, the doctor bills. If you're seeing a physical therapist or chiropractor, paying those bills. So we stay on top of your insurance company to make sure that they're doing their thing with the PIP benefits, with uninsured motorist benefits, with any sort of property damage or rental benefits. So we hold their feet to the fire for you to make sure that they're doing their job for the insurance that you paid for. And then on the other side, the third party side, we're preserving all the evidence. We're making sure that we can download the black box data. We're making sure that we could, take pictures of the vehicle before it gets destroyed or repaired or whatever they're going to do to try to potentially hide the evidence. And then basically you're going to be treating. Most people treat for approximately 6 months. Sometimes it's shorter, sometimes it's longer, depending on how bad the injuries are and how you're recovering. Depending on whether you decide that you need things like epidural injections or radiofrequency ablations, or if you need surgery, right? If you need some kind of spine surgery, whether it's like a cervical disc replacement, cervical fusion, lumbar laminectomy, or just a knee surgery or a shoulder surgery, what have you, right? But you treat for about 6-8 months, somewhere in that ballpark. Again, it could be longer, it could be shorter. There's no golden rule on that. But then once you're done treating, we've made sure all the PIP benefits are being paid. We made sure that your health insurance or whoever it is that is responsible after the PIP runs out is paying. Once that happens, then we get all your medical records, bills, all the evidence that we've gathered in terms of property damage, how the crash happened, the crash report, witness statements, whatever it is that we need to prove your case. And we send a legal demand package out to the insurance company for the at-fault party, demand a certain amount of money based upon how badly you're hurt. And then basically we get an offer. I always have two numbers for you when I start negotiating. One is the gross of what they're offering. The other is the net of what you'll get in your pocket. Because I've had so many people through the years come to me and say, oh, Mike, like my family member was taken advantage of where, the lawyer got paid and the doctors got paid and they didn't really get anything. That'll never happen at the Grife law firm, right? So you'll know before you settle your case approximately what you're going to get in your pocket. There's really no mystery, right? So once I get the offer and I start negotiating, get them to their highest offer, and I call my client and I say, hey, look, here's the gross of what they're offering. Here's the net of what you'll get in your pocket. Me as a 20-year lawyer, I'm telling you, I've been doing all personal injury and medical malpractice for 20 years, right? So I'll tell you, hey, look, I think it's a good offer, it's a bad offer, it's a moderate offer, whatever it is, and I'll give you advice about, hey, we should probably settle this and you can move on, or, let's file a lawsuit because they're really undervaluing your case, and let's go through the courts a little bit and see if we can get them to settle, and if not, then we'll do a jury trial as kind of a last resort. But I give advice and my clients make decisions. So I tell them, hey, here are your options. Here's my advice. Here are all the scenarios. Here are all the pluses and minuses. What would you like to do? Because the case is not about me. It's about my clients. And all I care about is that they're happy.
That is great insight, Mike. Thank you so much for breaking that down for us. And that leads into the next question. So, because most people assume it is just the medical bills and the car repair, but what types of damages can a Florida claimant recover? And then how does the HB 837 affect them?
So generally in Florida, the damages for car accident cases, tractor trailer, crashes, pedestrian crashes, whatever it is, okay? Normally the damages in Florida are broken into two categories: economic damages and non-economic damages, right? The economic damages are things you can kind of add up on a calculator pretty easily, right? Medical bills in the past, medical bills in the future, because a lot of times, you might need what's called a life care plan, where, a doctor examines you and says, hey, look, here are the medical bills to date, but this person is going to need, treatment or attending care or surgery in the future or whatever the medical costs will be in the future. So you got to prove all your damages. So you got past and future medical bills. You can have things like lost wages in the past or lost wages in the future. Same thing. If you're not going to be able to go back to work, or you're going to have to miss significant time in the future. So what you've missed at work and your wages up until the date of the trial or up until the date of the claim, and then in the future. So those are kind of the economic damages that you're entitled to in Florida. But really that doesn't make people whole, right? Because that's just kind of like the basement. That's the ground floor of, what you've suffered due to the negligence of the at-fault driver and things of that nature. So what about the fact that you were in agonizing pain for 6, 8, 10, 12 months? What about the fact that you couldn't go to certain events with your friends or your family? You couldn't travel, you couldn't enjoy your life. What about that, right? So that needs to be compensated as well. And those are called non-economic or human damages, which I would say are the most important damages, because what do we as Americans, what do we as humans value most? Our health. And if our health is taken through no fault of our own, because somebody's careless, they're looking at their cell phone, they're texting, they're drinking, they're not watching the road, and they crash into your car, they crash into you, you have to be fairly and fully compensated, okay? So things like pain and suffering in the past and the future, mental anguish in the past and the future, loss of capacity for the enjoyment of life, because what do we talk about? Life, liberty, and the pursuit of happiness, right, Abby? So, if we lose the capacity for enjoyment of life, for happiness in the past and the future, that has to be compensated as well. Inconvenience, right? I've had to go to all these doctor appointments, all these physical therapy appointments. I had to take off work. I couldn't, take care of my kids. I had to get someone to watch them for me. I couldn't walk my dog. I couldn't do this. I couldn't do that. That's real. I had to take off 7 days to go do this jury trial. That's real. So you need to be compensated for that as well. The thing that HB 837 did was it made it, and this is kind of even a raging debate throughout Florida right now, because HB 837 is so new, it hasn't gotten a lot of appellate court treatment. At some point, it's going to get some appellate court treatment, and a lot of these rules will be kind of decided, unless HB 837 gets overturned or modified, which fingers crossed it will. But in the event, in the way that it stands kind of right now is HB 837, the reasonableness of your medical bills is kind of up for a further debate than it was before. And the defense can put in evidence of, what certain insurance companies, or in some cases, what Medicare would have paid and things like that. And they could really attack the injured parties' medical bills and things of that nature. So, HB 837 kind of, allowed the defense a lot of latitude to get into evidence that, frankly, I would argue is irrelevant and, harassing and burdensome and things of this nature. Because, if you're hurt through no fault of your own, you don't want bargain basement medical care. You want top level medical care. That's what you deserve. And that's what should be, provided to you. So it's a little bit, I think HB 837 allows a lot of misleading and just unfortunate evidence to come in. But again, we're still winning our cases. We're still doing great. We're still prevailing. So it's not that big of a deal.
All right, we have covered the no-fault system, the serious injury threshold. You broke down HB 837's rewrite and the full claim sequence. So now let's talk about the mistakes the insurance company is counting on you to make. So most people assume the adjuster is trying to help them. Why is giving a recorded statement to the at-fault driver's insurer one of the most damaging mistakes in Florida?
Great question. So after a car crash, most people aren't necessarily in their right mind or aren't their normal self. They're not as sharp as they would be. They're not as aware as they would be. And they kind of think like, everyone's on their side, maybe. Not the case. Even your own insurance company isn't on your side, let alone the at-fault insurance companies. You give a recorded statement to the at-fault insurance company and even casually say the wrong thing, even casually, oh, that's not what I meant. I know I said that, but I didn't really mean that. Or you're not really thinking right, or you don't word something the right way. They could use that against you. And you want to sit down before you call your own insurance company, let alone take a call from an adjuster that's probably just trying to save their insurance company as much money as possible, not put the right money in your pocket, right? Before you would speak to someone adversarial, you want to speak to a lawyer who can give you cogent legal advice on how to answer the questions, who can be there sitting next to you and kind of like while you're giving this statement, and really help you, give you moral support, legal support, and every other sort of support you need. Because if you just casually misword something, or you're not really thinking because you're not as sharp because you're in pain, and you say something wrong, that could be used against you throughout the life of this case and the life of this claim. And it could be 2 years later, 3 years later, and you're in a jury trial, and they can take out that recording and say, hey, remember when the adjuster called you like 2 days after the crash and you said this, that, the other thing, and you say, oh no, that's not what I meant, or I was just estimating. I didn't really know. I just wanted to get off the phone. I didn't care. Like, no, it's very, very important. So, before, like, you wouldn't operate on yourself, right? If you hurt your knee after a car crash, you wouldn't just say, hey, like, I'm just going to, operate on myself, like, all good. No, you get a doctor. So before you give a recorded statement to an at-fault insurance adjuster or even your own insurance company, get a lawyer, get someone on your side, get someone who's going to help you to be successful. It's so mandatory. It's so necessary. I've seen so much unscrupulous and immoral conduct on the part of these insurance companies, and do not let yourself fall victim to it. Hire a lawyer who's going to help you prepare for these statements, who's going to gather the evidence, go through the evidence with you, take a very caring approach of getting you ready, sit next to you or be on the phone, what have you, to help you through. Very, very important.
And then continuing to talk about mistakes, I'm sure you've seen this mistake that is one of the easiest to avoid, and it's the one that trips up the most people. How does social media activity destroy a Florida car accident claim?
So here's what I would say, Abby, to all the people out there. Would you pay tens of thousands of dollars for the right to post on TikTok or Instagram or something like that? Of course you wouldn't. No one's going to say, hey, yeah, here's 50 grand. Can I post on TikTok? Here's 50 grand. Can I post on Instagram? No way, right? But if after a car crash, you're posting on TikTok or you're posting on Instagram or Facebook or whatever it is, it can cost you tens of thousands of dollars because, these insurance companies and these defendants, they don't care about the context. They don't care if, hey, I was in 8 out of 10 pain agony for 8 days in a row. And on the 9th day, I took whatever I needed to take so I could feel at least okay to get out of bed. So I wanted to, just post and with my family or friends doing something because I wanted to get a little bit of enjoyment. Nope, that will be used against you. If you travel especially, and even though you were in agony on the plane, but you had these plans before and you just couldn't afford to reschedule and you had taken off of work or what have you, and you post from anywhere outside of, where the area where you live, the defense is going to get this evidence. Even if you do stories, the defense can get that evidence. Don't think it just disappears after 24 days. It stays on your account, right? So again, you wouldn't pay tens of thousands of dollars, or even in some cases, hundreds of thousands of dollars just for the right to post on TikTok or Instagram. Of course you wouldn't. So after a car crash case, don't post on TikTok, don't post on Instagram, don't do these things because it could cost you a lot of money.
And then the carrier might send paperwork that looks routine, but why is signing a broad medical authorization after a Florida crash a serious trap?
Yeah, so you don't sign a broad authorization and give them a total backstage pass to your entire life and medical history when you don't have to, right? That's even your privacy laws. Like in Florida, we have a right of privacy in our Constitution that says it's Article 1, Section 23, that says we have a right to privacy. So, you wouldn't give like your opponent a backstage pass, right? Like, if the Miami Dolphins are playing the San Francisco 49ers, they don't say, hey, here's an authorization to our practices. Why don't you guys come and see what plays we're going to run and things like that? You wouldn't do that. So by the same token, broad authorizations like that are most times not warranted and certainly not helpful. You want to control the flow of evidence as much as you can so that you can present your claim in a light most favorable to you, the injured party. So, preserve your right to privacy to the fullest extent that you can. Sometimes you might have to sign an authorizations. Most times you don't. So, that's why another reason to hire Mike Grife for the Grife Law Firm or a really skilled, talented lawyer, right? Because they're going to tell you, hey, look, we're going to control the flow of evidence. You don't need to sign this. Let's make sure that the defense gets the information they need to fairly, adjust the claim, but they don't need all of this excess information, right? Like if you're a lady, like, do you want your OB records out there, your GYN records? Of course you don't, right? Like you're making a claim for your back. So it's like, don't give broad authorizations that violate your dignity and your right of privacy. Maintain your rights, maintain your dignity, and I'll make sure I fight for it.
Then the first number might come in and sound good because it arrives fast, but not because it's fair. Why is accepting the first settlement offer one of the most expensive mistakes a Florida claimant can make?
So you don't accept the first offer, right? Like you almost never, ever, ever accept the first offer because it's a negotiation. They're trying to see how much money they could save. Their reserves are set a lot higher, these insurance companies, than what they offer out of the gate. So they know that, if they offer the full value of the case right away, you may or may not say yes, or you're going to expect more. But they know if they start low, you know what I'm saying? Like they're going to try to save as much money as they can because maybe there's an unaware plaintiff, an unaware injured party that thinks that's a lot of money, even though it's half or a third or a quarter of what the case is actually worth. That's why when you hire a lawyer, they could really analyze everything as someone who goes to trial, someone who knows what a jury's likely going to do, someone who knows what a verdict form looks like, right? And the different damages that you can collect. They can give you really good, cogent advice on what a good offer is. And it's almost never the first offer. So the first offer is just, like a bargaining tool, right? Like when you're buying a car, when you're buying a house or whatever it is. So, normally if you're listing your house for $1 million, someone doesn't come in and say, hey, here's $1 million, let's wrap this up. They say, hey, here's, 850 or whatever it is. So, you don't want to take the first offer. You want to negotiate, especially like I was saying before, because a very shady tactic that a lot of these adjusters like to do is after a car crash, they'll speak to the victim before they could hire a lawyer and say, hey, why don't you sign this release for $3,000? I'll give you $3,000 right now and you can walk away. The person has no idea how badly they're hurt. They're still under the fog of the injuries from the crash and, not of the right mind. And sometimes they say, hey, I could use $3,000. Boom, I'll sign this. You might have just forfeited your rights to, hundreds of thousands of dollars by signing that. So you don't take the first offer. You negotiate. Just like, we start high, they start low. You see if you can meet somewhere in between. But taking the first offer is not the move.
Gaps in care are the thing the carrier is hoping for. Why is missing the 14-day window or letting treatment lapse so damaging in Florida?
Yeah, so what the defense likes to argue is basically, if you're hurt, you're going to treat. Don't tell me you're hurt, show me you're hurt. And the way, again, to get the evidence to show the insurance company or the adjuster or the jury or whoever it is, the mediator, the arbitrator, that you're hurt, is by treating, not having big gaps in treatment, right? Because what the defense will do is they'll probably do some kind of timeline. Oh, so they went to see the doctor in May of 2026. They treated for a few weeks, and then we have 5 months go by where they're not seeing anybody. What are they doing in that 5 months? Then all of a sudden they go back, and now they're having back pain again. Well, who knows what happened during those 5 months to make them go back? And they try to make it seem very sinister, when in reality, a lot of people just have a life to live. And who likes going to the doctor's office? Almost nobody, right? So it's like, but when you have an injury case, they kind of put the victim on trial sometimes. And they want to say, if you're not treating, you're not really hurt. So that's why you do not want gaps in treatment. You want to get in and see your doctor and see the physical therapist and see the chiropractor and get your treatments, get your injections or whatever it is that you need to try to feel better. And that also, of course, Abby, dovetails with the PIP laws, which is, you have 14 days within which you have to treat after the crash. And if you don't treat, you forfeit those benefits. So you want to treat early. I mean, I think you want to treat right after the crash, within 24 hours, certainly, I wouldn't even push the 14 days, but you definitely got to treat within 14 days. And then while your case is pending, even though you're busy, even though you're hardworking, you have a family to take care of, or you have to pay your own bills, whatever, find time for yourself. Take care of yourself, right? Treat with these doctors so you could feel as good as possible, be the best version of yourself, and get full justice for your case. Because again, this is really important to remember. When you settle your case, that's for a lifetime. You can't go back after you settle your case or after you get your jury verdict and you get your judgment. You can't go back 6 months, 6 years, or 10 years later and say, wow, I didn't make as good a recovery as I thought I would. My back is still hurting. My neck is still hurting. My knee is still hurting. I need treatment. When you settle, that's for your life. That's for it's got to last you forever. So prove it with the evidence by treating. Don't let big gaps in your treatment happen so that a great lawyer like myself can get you the most amount of money possible.
A lot of people assume that if they were partly at fault, the claim is over. Why do many Floridians assume partial fault disqualifies them from recovering, and why is that often wrong?
Yeah, so even if you're partially at fault in Florida, you could still recover your damages, okay? Your damages will be reduced by your percentage of fault. For example, if you were 20% at fault or 30% at fault, we'll put right in the middle and say 25% at fault, and you get $200,000 worth of damages, then it would just be reduced by that 25%. So it would be reduced by 50,000, and you would wind up with 150,000, right? And you could do that up and down the line. Now we know with HB 837 that we have modified comparative fault now, which means that if you're 51% or more at fault, then you can recover. But let us decide if we can prove that the fault is 50% on the defendant or greater, because you could still recover, especially if you're badly hurt, right? I mean, this is your one chance to get, compensation for what you've been through, for your medical bills, for your lost wages, for your property damage or diminution of value, for your human damages, for your anguish and suffering and things like that. So even if you're a little bit at fault or even, moderately at fault, we could still get you a great result. So, let a lawyer analyze your case, a professional, people who litigate, people who go to trial, people who are really in the trenches of law, who are, doing our thing and helping, innocent, injured victims. You might think you're more at fault than you are. You might not be not at fault at all, right? So we can really analyze it and tell you, hey, look, this is a really good, viable case. You might be a little bit at fault. That's no problem. But, we could still get you an absolutely great result. And we're going to be real with you, right? Because it's about treating people the way you want to be treated. So I think to myself, what if I was going to go see a lawyer, right? What would my expectations be? And I want to meet or exceed those expectations every time, because I do have high expectations, right? So I want to be treated well, and I want to treat people well, and I want them to benefit from my knowledge and experience. So don't think you don't have a case just because you're partially at fault for, a car crash. It's still incumbent on the other person to do everything they can to avoid the crash. Or if you're crossing the street, they got to do everything they can to avoid you. So, let the professionals, kind of judge whether or not you have a case. Even if you bear some fault, there's a really good chance that we're still going to get you a great result.
All right, we have covered the mistakes that quietly sink cases. Now let's get into the deadlines, the courts, and what actually happens if the case has to be filed. So this is one of those deadlines that can end a case permanently. What is the statute of limitations for a Florida car accident lawsuit today, and what special deadlines apply to government vehicles?
Yeah, so in Florida, the statute of limitations is 2 years now. We know that HB 837 shortened the statute of limitations from 4 years to 2 years when you're going after third parties, meaning the other driver, the employer of the other driver, or the vehicle owner. Because let's not forget, in Florida, if someone loans someone their car and they're not driving, that vehicle owner is still legally responsible under the dangerous instrumentality doctrine that we have here in Florida. So to go against the at-fault party, the owner of the vehicle, if there's an employer-employee situation, the corporation they were working for, that's now 2 years from the date of the crash. But when you're suing a government entity, there's more that comes into play, right? You have to put them on notice. There's sovereign immunity, and you have to put them on notice, and you have to give them a wealth of information like your name, address, date of birth, where you were born, a description of the claim, things like that. You want to provide that to the government agency as quickly as possible, because then they have 180 days within which they can adjust that claim, or they have to have that notice. Then you can file your lawsuit. So you want to make sure you get that statutory notice out as quickly as possible so that you can open the doors to the courthouse if you need to, if they're not going to treat you right.
Most people do not know how fault actually gets assigned in the first place. So how is fault determined in a Florida car accident claim, and how much weight does the crash report carry?
So that's a great question. So if you think about a pie, like 100% of a pie, right? That's kind of like how liability gets apportioned. It could be any percentage of that pie, can go to either party. Or sometimes there's 3 people involved in the crash, right? So you divide it between 3 people, but it's out of 100%. Okay. If you're like me, you think of a pizza pie, but maybe some other people think of some other pies. But in any event, so, basically the jury, like the first question on a verdict form is, was the defendant the legal cause of injury, loss, damage to the plaintiff? Yes or no, right? We're hoping that the jury is going to say yes. Okay. The second question can be, was there fault on the part of the plaintiff that was the cause of loss, damage, or injury to the plaintiff? Yes or no? Now, if the jury selects yes for that, the third question is normally, what is the percentage of fault that you assign to the defendant? What is the percentage of fault that you assign to the plaintiff? And that must total 100%. So that's kind of how liability really gets distributed. The crash report, to be honest with you, Abby, where it could be influential during pre-suit when you're negotiating, but once you litigate the crash report, you could tear it up and throw it in the garbage. The crash report is completely inadmissible unless the police officer actually witnessed the crash. Then they really can't talk about how the crash happened. They can't assign fault or anything like that. It's really about they could read their report, right? And they can say, I reported to the scene. Even what you say to the police, though, and what you say to law enforcement after the crash is privileged as well. So that's interesting. So because Florida law wants to foster open communication with law enforcement after a crash, they make it such that all of the statements that you give to law enforcement are privileged. So that's really interesting. So the crash report, again, I think people kind of look at it during pre-suit and say, oh, well, even the officer said that this person was at fault. Okay, fine. But once you get into litigation, toss it out.
And you mentioned earlier, Florida does not require bodily injury liability on most drivers. So what happens when the at-fault driver has no coverage? What happens when the at-fault driver is uninsured, underinsured, or flees the scene in Florida?
Yeah, so if the driver has no bodily injury insurance or flees the scene and can't be found, the only way that you're going to recover above your PIP $10,000 medical benefits is if you have uninsured, underinsured motorist coverage. And why this coverage is so important is it does 2 things for you, right? 2 crucial things for you after a crash. Number one, if the at-fault driver had no bodily injury insurance or they flee the scene, like you mentioned, and they can't be found, they step in. your insurance company, and this is another reason, Abby, why it's so important that you speak to a lawyer even before you give a statement to your own insurance company in Florida, because there might be a lot of scenarios where you're, suing your own insurance company, or you have claims against your own insurance company because under uninsured, underinsured motorist coverage, they stand in the shoes of the at-fault driver. So again, in the scenario that you mentioned, there's no bodily injury insurance, or they fled the scene and can't be found. Now, if you have uninsured motorist coverage, boom, your insurance company stands in the shoes of the at-fault driver up to your limits, whether it's 25,000, 50,000, 100,000, 250,000, 500,000. Some people have uninsured motorist coverage umbrellas with millions and millions of dollars, which is great. If you could afford it, I highly recommend getting as much uninsured, underinsured motorist coverage as you can afford. But then the other scenario where this coverage comes into play is, let's say the person who causes the crash has bodily injury insurance, but not enough to cover your damages. Sometimes people only have $10,000, which might seem like a lot of money, but not if you have a big hospital bill and you're out of work and things like that. Sometimes they only have $25,000. So what if the at-fault party has even $50,000 of coverage, right? But your damages are worth $300,000, $400,000, $500,000, $600,000, right? You're leaving all that money on the table unless if you have uninsured, underinsured coverage. Boom, now your insurance company steps in. So the difference between where the defendant's bodily injury coverage ends, that's where they basically step in. So if the defendant had a $10,000 policy, all your damages above $10,000 are onto your uninsured, underinsured motorist coverage, and then you can collect up to those policy limits, and then sometimes you can even collect more than the policy limits. So that's why these coverages are so important. And I know insurance is one of those things that nobody wants to need, right? Nobody wants to, you don't really want to pay for it because you're hoping you don't need it, but it's you want to have that umbrella on a rainy day. You know what I'm saying? You're planning this beautiful, beautiful outdoor outing. If you're like me, you're going boating or you're doing whatever it is that you love to do outside. But hey, what if it rains? You know what I'm saying? People, you get married, right? And there's always two ideas. Normally one is oh, we might do this beautiful outdoor ceremony on the beach, but if it rains, we have a backup, right? So that's you always want to have uninsured, underinsured motorist coverage because you want to have a backup, because Florida's got these weird laws. There's no bodily injury coverage necessary. And I know you want to keep your premiums down, but uninsured, underinsured motorist coverage is too important not to get.
Then you also had an example earlier about this. Commercial and rideshare cases are completely different categories. What specific considerations apply when a commercial truck or rideshare vehicle cause a Florida crash, and when should someone hire an attorney?
Well, I would say after a rideshare crash caused by Uber or Lyft or any sort of commercial vehicle, hire an attorney right away. Because that's, these people have all these insurance adjusters and investigators that are on their side immediately after the crash, right? Because these are professional drivers, or in some cases want to be professional drivers. And these companies are, basically built with all these policies, procedures, investigators to go investigate and get evidence, not for you, but for them. So put someone like me on your side, because I will gather all the evidence for you. I will, get all of the information needed to prove your case and win your case for you. So you should hire an attorney right away, because this evidence can get destroyed. Again, once the commercial vehicle, the Uber vehicle, the Lyft vehicle, the rideshare vehicle, once that's the repaired, or, if the car is totaled out and junked or sent overseas or whatever they do with it, that black box data, that event data recorder might be gone forever. You don't want that to happen. So hire a lawyer right away. But here's something kind of cool about Uber and Lyft. So, and all these rideshare companies, they're mandated to have $1 million worth of bodily injury coverage, right? Now that can change because they pass some laws where it depends on if they're on the app going to pick up a passenger, or on the app, in the middle of a ride. So that could affect that $1 million. But they're required to have $1 million worth of insurance. So if there's a rideshare company involved, you don't have to worry about no bodily injury insurance like you have to do in some other situations. And in commercial motor vehicles, especially tractor trailers, they're also required to have large insurance policies for interstate vehicles and things of that nature. most of the time for commercial motor vehicles. They have very large policies. And the thing about, Abby, commercial motor vehicles is a lot of times you're talking about dump trucks, big work trucks, things like that. And these things cause significant harm because of the force, the G-force, everything like that involved in that crash. If you're driving a little coupe or sedan, or you're on foot and you get hit by a 50, 60,000 pound tractor trailer, or even, 7,500 or 15,000, whatever it is, pound vehicle with work equipment and what have you in it, that's a big crash. That's a lot of impact that your body's not really used to take in violent forces. So there's a lot of considerations when you're talking about rideshare vehicles, when you're talking about, at least $1 million in coverage. You're talking about tractor trailers, trucks, everything like that. So what I like to tell my clients is hire me. All I want you to concern yourself with is getting better, taking care of your family, doing what you need to do to feel good. I'm going to worry about all the legal stuff, the investigation, the medical bills, this, that, the other thing, the rental car. Put that on me, and let's just get you feeling better.
Mm-hmm. Well, Mike, this has been incredibly valuable. Florida's system has more tripwires than almost any other state, and the 14-day rule alone is worth this whole conversation. So for someone listening right now in Boca Raton who was just in a car accident, what is the one thing you want them to remember?
Hire a lawyer as quickly as possible. And I am not just saying that because it's what I do for a living. I'm saying that because you have one shot to make it right. You know what I'm saying? You have one shot to get justice. Don't blow your chance. Don't be cavalier. Don't think like, hey, like I just want this over with as quickly as possible, because your health and your happiness are worth a lot more than that. All these insurance companies, you get into a car crash, right? All these insurance companies have investigators. They're sending people to the scene. They're gathering evidence. And if you're just sitting back, then you're like lambs going to be led to the slaughter potentially. Hire a lawyer that's going to do the same for you. I'm going to go out to the scene. I'm going to gather all the evidence. I'm going to hire engineers. I'm going to hire accident reconstructionists. I'm going to download the black box data because my client's going to win, period. So, hire a lawyer after a crash. Also to help guide you about things like the 14-day PIP rule and all these other things to make sure that you get all the benefits. You're paying all these insurance premiums, so you deserve these benefits if you need them, to make sure that the at-fault party is held fully responsible. I just had a case. Here's an interesting scenario. I had a case where my client was involved in a very, very significant crash, and he had a spine surgery. And all the defendant represented was that she had a $250,000 policy. But I just kind of had a sixth sense that there was more out there, especially because $250,000 is normally the minimum threshold to have an umbrella. So when the insurance company paid me the $250,000, I didn't just go run to the bank and deposit the check and say, celebrate or whatever. I said, no, I think there's more out there. I said, we're not going to take this $250 unless I get an affidavit from your insured, the at-fault driver, stating that there's no other policies. 2 days later, we get a call. Hey, so as it turns out, there is $1 million umbrella, right? So that's why it's so important. These insurance companies will hide the ball. They will do unscrupulous things. They will try to get you to sign releases 2 or 3 days after the crash before we even realize what your damages are and how bad you're hurt. So hire, and also the other thing is pick the right lawyer. You know what I'm saying? Don't do a mill firm, fly by night, a lawyer who's just looking to make a quick buck because they need to put, gas in their car or whatever it is. Hire a lawyer and a law firm with track records of success that are really, really true plaintiff and injured advocates. That's what you need.
And if someone wants to talk to you about their car accident claim, what is the best way to reach the Grife law firm?
Yeah, I love to talk to people after a crash because I know I'm going to do a phenomenal job for them and treat them like family. So the best way to get in touch with me is to call my firm at 561-998-0 and ask to speak to me, Mike Grife, directly. I'm happy to get on the phone with you, put my knowledge and expertise and resources to work for you to seek full justice on your behalf.
And that first consultation is free, correct?
Absolutely. The first consultation is gratis. It's free. It's just us getting to know each other a little bit. Are we a good fit in the lawyer-client relationship? Do you like what we could do for you? Do you sound like you have a good case? How could I put the law on your side? How can I advocate for you in the strongest possible way? How can I collect all the evidence? Let me lay out the case for you. A lot of my clients have never sued anybody, right? A lot of my clients, and some unfortunately have had to sue people in the past because they've been wronged. But a lot of my clients call me, Abby, and they're like, I've never done this before. I've never sued someone before. And I say, I get it. I totally get it. So let's talk about what it is. It's not that big of a deal. Let's talk about how we're going to handle it. So more than happy to speak to someone, offer a free consultation right after a crash. And if they like our vibe and they like what they could do for us, then great. Then please hire us. It's a total contingency fee, meaning that there's no financial outlay for the injured person unless we win the case. So there's no invoice, there's no retainer. They don't pay me anything unless we win the case. So the consultation's free. The fee is contingent upon us winning. So it allows, everyday people to hire great law firms like ours and, have that legal muscle on your side throughout the entire case and only pay when it's over.
All right. If you have been in a car accident in Boca Raton or anywhere in Florida and you are not sure what to do, make that call. You can find the Grife Law Firm at michaelgrife.attorney or call them directly at 561-998-0770. Thanks for watching, and we will see you on the next episode of the Grife Law Podcast.